This is Bloomberg Law with June Grasso from Bloomberg Radio.
For count one, aggravated murder, a capital felony in violation of Utah Code annotated 76-5-202, in that on September 10th, 2025 in Utah County, the defendant, Tyler James Robinson, intentionally or knowingly caused the death of Charlie Kirk.
22-year-old Tyler Robinson appeared in court for the first time on Tuesday to face aggravated murder charges for the fatal shooting of conservative activist Charlie Kirk. Utah County Attorney Jeff Gray said they'll seek the death penalty, explaining the aggravating factors.
The state is further alleging aggravating factors on counts 1 and 2 because the defendant is believed to have targeted Charlie Kirk based on Charlie Kirk's political expression and did so knowing that children were present and would witness the homicide.
During the 10-minute hearing, Robinson, who was wearing a green vest designed to prevent self-harm, showed no emotion and didn't speak except to state his name.
State of Utah versus Tyler James Robinson. Could you state your name?
Tyler James Robinson.
Robinson faces 6 other charges in addition to the aggravated murder count, including obstruction of justice, witness tampering, gun charges, and committing a violent offense in the presence of a child. Joining me is Bloomberg legal reporter Madlin Mekelburg. Madlin, tell us about this first court appearance for Tyler Robinson.
Tyler Robinson came before a judge for the first time this week, and it was a virtual appearance in a courtroom, which is pretty standard apparently for criminal cases in Utah County where he was charged. And he appeared via Zoom from the jail, and the judge who will be presiding over the criminal case moving forward read the charges aloud to him, informed him that there was a possible sentence of the death penalty associated with those charges, and he asked him if he had an attorney yet. And he does not have a lawyer. The judge said based on his financial status, one will be appointed for him, and that's something that we can expect to happen in the next few weeks here.
And that lawyer is going to have to be one that's certified in the state to represent capital defendants, so that will limit the choices somewhat. Did Robinson enter a plea?
No, we're not going to see him enter a plea for at least a few weeks. The way that things work in Utah, the next hearing is also going to be virtual, and they'll be discussing whether or not he wants to waive his right to a preliminary hearing. This is a hearing where they would talk about whether there's enough validity to the charges to move forward to an arraignment, which would be yet another hearing where he would actually enter a plea to the charges before him. So a long road to go before we get there.
And from what authorities have said, he has not made a confession and he's not talking to investigators.
So Utah County Attorney Jeff Gray has been the public face of the prosecution so far, and he's really declined to weigh in on exactly how much Robinson may or may not be cooperating with investigators. But we heard previously from law enforcement authorities that he has not been cooperative with them. There's no evidence so far that he's given them any kind of confession or admitted to anything. Although I'm sure you saw prosecutors released a ton of evidence that they say they have against him, which include text messages where he's talking about the shooting. But they declined to say whether they construe those as being a confession. And at this point, we have no reason to believe that he's confessed to authorities or that he's even cooperating with them.
Let's talk a little bit about those text messages to his roommate and why prosecutors are highlighting them.
So while he may not be cooperating with them, it's very clear that his family and people close to him are, or at least have been, providing law enforcement with information regarding their communications with him leading up to the shooting and following the shooting. Now, prosecutors say that he was in a romantic relationship with his roommate and that when he was on campus allegedly committing this act, he sent a message to his roommate telling them to look under his keyboard of his computer. And when the roommate checked under the keyboard, there was a note there that said, quote, "I had the opportunity to take out Charlie Kirk and I'm going to take it." And what followed is a series of messages that are allegedly between the roommate and Robinson. You know, the roommate is expressing confusion, shock, saying, "You're joking, right?" And Robinson apparently said to them, "I'm not joking. The roommate says, "You weren't the one who did this, right?" Robinson says, "I am. I'm sorry." And they go back and forth in this exchange, and Robinson apparently is talking about how he attempted to hide his rifle, how police arrested somebody at the shooting who was not him. I'm sure you remember those hours afterwards when police kept saying they had someone in custody, but they were not the suspect in this case. So I think the messages are significant because it clearly shows that Robinson was talking about doing this and explaining some of his thought process behind it, which is that he said, quote, "I had enough of his hatred," talking about Kirk.
And prosecutors say they also have some physical evidence, DNA evidence.
Right. So prosecutors say that they have DNA from the trigger of the rifle that they believe was used in the shooting and the towel that the rifle was found wrapped in when they recovered it from the scene. They say the DNA they collected there matches Robinson.
And what about his conversations on Discord? The FBI director said that they're investigating the people who were involved in those conversations.
Apparently, Robinson was having conversations on Discord, which is a popular chat application that's used for people who play and stream video games, is my understanding of it. But apparently he was having a conversation with a group of friends and making jokes about the shooting and connecting himself to it without admitting anything. And those conversations have been discussed by, as you say, the FBI director and some officials publicly, but they're not actually mentioned in the charging documents that we saw filed from prosecutors. So we have to assume that'll be part of the evidence that they present against him at some point, but it hasn't been part of this initial charging.
Prosecutors didn't out and out state a motive, did they? Although in the documents there was a reference to Robinson becoming more pro-gay and trans rights oriented.
No, so they talked about the political elements of the situation here, but they have said that they're not talking about a motive at this point. They're only talking about the evidence that they have, which seems to include statements from Robinson's mother, who's the one who told investigators that in recent years her son had become more politically engaged with some of these left-leaning causes and more pro-gay and trans rights focused. That's something that was in the charging documents. And that seems to be significant because his family said that they identify as being more conservative voters.
The county prosecutor described political motivation as an aggravating factor for the capital murder charges. So where does that fit in their case?
Prosecutors noted in the charging documents that Robinson intentionally selected Kirk because of his perception regarding Kirk's political expression. So that's the mention that we've seen from prosecutors in the formal court documents, that he was motivated by the political expression, but they haven't declared that as the official motive, but they've noted that that was part of why Robinson allegedly decided to shoot Kirk.
Do authorities consider him a sole actor here, or are they looking for accomplices?
So at this point, prosecutors and law enforcement say that they are continuing investigating. They're leaving no stone unturned, but they've declined to answer questions of whether they believe he acted alone or this was a coordinated attempt. And so at this point, nobody else has been named as a suspect or even as somebody who has contributed to this in a different way. And so the investigation continues. It's possible that we see future charges against another individual, but at this point, there's no evidence to suggest that they have somebody else in mind.
Are the feds also considering bringing charges against Robinson?
I think that's certainly a possibility. We've heard people in the Trump administration say that that's something that they're looking at. Prosecutors in Utah County declined to answer questions about that as well. They said that's a decision that's totally up to the federal government if they have charges that they want to pursue at a federal level. Nothing's been filed yet, but, that's always possible.
Before Robinson was even arrested, Utah's governor said they would pursue the death penalty. And yet on Tuesday, the county prosecutor said he came to the decision to seek the death penalty independently.
So there's been a lot of talk about this. The Utah governor came out and said that he was planning to pursue it. President Trump has said you need to pursue the death penalty. And when we heard from the county attorney this week, he said he made this decision independent of any outside influence, and that while he spoke with both the governor and the president, at least representatives for their respective administrations, he said he didn't receive pressure from them to make that decision, and they didn't raise it with him. So he's wanting to be clear that this is something he's pursuing based on the evidence that he has. And part of that is this idea that when the shooting occurred, there were children present, and there was also a risk of injury to other people that were there. So it wasn't a straightforward murder where it was just between two individuals. He was firing a shot across a crowd of people, and there was risk of injury to others who were there.
Utah was the first state to carry out an execution after the Supreme Court put the death penalty back on the books, so to speak. How many executions has the state carried out since then?
So Utah is one of 23 states in the U.S. that currently allows for the death penalty to be imposed on an individual. Compared to other states, they have had less executions. Typically, when you're talking about the modern era of the death penalty, we look at executions since 1976, which was when the Supreme Court said that it is legal as a form of sentencing. And so since then, Utah has executed 8 people.
And Utah is one of a handful of states that allow executions by firing squad.
Every state that allows for the death penalty, their primary means of administering it is through lethal injection. But Utah is unique in that it's one of just 5 states that allows for a firing squad to be used in executions, but that's only in the situation where the state can't acquire the drugs that are required for lethal injection.
The last time the firing squad was used was in 2010, not so long ago. The next hearing for Robinson is on September 29th, so we should learn more then. Thanks so much, Madlin. That's Bloomberg legal reporter Madlin Mekelburg. Coming up next, an unprecedented number of threats against federal judges. I'm June Grasso, and you're listening to Bloomberg.
It went beyond just me. You know, the court staff had to listen to this, and our court received over 400 vile, threatening, horrible voicemails. I've been on the bench almost 15 years, and I must say it's the one time that actually shook my faith in the judicial system, in the rule of law, in the work they do, our Constitution, and whatnot.
Threats against federal judges have increased dramatically. The U.S. Marshals Service has investigated more than 500 threats against 364 judges in the last 9 months alone. One of those judges is John McConnell, the chief judge for the District of Rhode Island. He got hundreds of death threats after he issued a ruling that blocked President Trump's freeze on federal aid.
And I experienced a period of a few months, and my family did, of incredible personal harassment, attack, and threats that go to the very core of those constitutional principles that we all uphold. I mean, I told you about the 400 or 500 vile phone calls. There were 6 credible death threats against my life. Someone was on the dark web searching for my home address because, this is a quote, he wanted Smith & Wesson to pay me a visit at my home.
In response, on Wednesday, Constitution Day, a group of nearly 50 former federal judges published an open letter warning against attempts to intimidate and pressure judges and threaten judicial independence, saying the Constitution is under attack. Joining me are 2 of those judges from the Keep Our Republic's Article 3 coalition, Judge Andre Davis, formerly of the U.S. Court of Appeals for the Fourth Circuit and the District Court of Maryland, and Judge Paul Michel, formerly of the U.S. Court of Appeals for the Federal Circuit. Thank you both for being here. Judge Davis, tell us why your group of retired judges decided to publish this letter.
We're seeing the same thing, namely an unprecedented and very dangerous attack on the judiciary, on the third branch of government in the United States, and putting at risk not just the rule of law and our democracy as we know it, but the actual lives of judges and their family members. And so that's what prompted us to take what I think is an unprecedented step ourselves by coming together as a group of retired judges appointed by presidents from both parties to speak with one voice and call attention to the danger that is not just implicit, but unavoidable in the kinds of rhetoric being used and the direct attacks on the judiciary and the rule of law. And so we're speaking with one voice to, one, educate the public and to speak out in support of our colleagues who work day in and day out to do the people's work in dispensing justice.
Judge Michel, there's a lot of rhetoric against judges coming from the top of the executive branch. As retired judges, what can you do to stop it?
Well, my hope is that if the citizenry can be better educated about the proper function and duties of judges, they will see that the threat to judges is really a threat against their own rights being protected by courts. Courts have to be independent of political pressures, whether from the White House or the Justice Department or elsewhere. And that is what's under attack now. And we think that we have unusual credibility because we're so nonpartisan, non-political, or you could almost say bipartisan, because we have about half our judges appointed by Republican administrations and half by Democratic administrations. And we're enormously diverse personally. But as Judge Davis rightly says, we're completely united in being horrified at the status quo, feeling like this is a moment of grave danger for our country, our democracy, and the rule of law. When you come right down to it, at the end of the day, either the written law is going to control or what the executive wants is going to control. Is it the rule of law or the rule of a king? That's what really is at stake here. And we think that the shrill attacks can be discouraged by the media and the citizenry objecting loudly to that kind of language, whether it's from congresspersons calling for impeachment of a judge simply for doing his or her job and ruling on a case, or coming from the White House or the Justice Department. And this is a moment of enormous danger for our country. One of the problems is the citizens have been very much misled. Too many of them are not well versed in understandings of basic constitutional government procedures and structures in our country. So, for example, the most important thing citizens need to realize is the job of a judge is not to promote the agenda of any president or any political party. The job of a judge is strictly to apply the written law, the precedents, and the statutes to the case.
The administration has been running to the Supreme Court when lower courts rule against them. And the Supreme Court has sided with the Trump administration in the vast majority of emergency cases decided since January. And more than a dozen times, the court has lifted an injunction issued by a trial judge who said the administration was probably acting illegally. And the court has sometimes written a few sentences in explanation, but sometimes none. And I'm wondering if that gives the average person a distorted view of what the lower courts are doing in limiting the administration and what the Supreme Court is doing in allowing the administration to move forward.
Well, you put your finger on something that's very, very, frankly, disheartening about the current legal landscape. The point is that every federal district judge, without exception, who has ruled against some policy of this administration was acting in absolute good faith in his and her attempt to interpret not just statutory law, not just constitutional law, but the Supreme Court's own precedents. That's what the federal district judges around the country have been doing for the last 7 or 8 months. And in those instances, I would even say most of those instances where the administration has appealed those adverse decisions by federal district judges, in most instances, the federal appellate courts have largely left in place the orders of the district judges. So what we see in the so-called shadow docket is that the Supreme Court is reversing the decisions in large part without explaining how or why those decisions are being reversed. And so that leaves, in the mind of many lay people, this very distorted view somehow that the lower federal courts, the district judges who hear from the parties, hear from the lawyers, consider the evidence, make a ruling, which is then left in place by the intermediate appellate court, and the matter gets up to the Supreme Court, and the Supreme Court, in one or two sentences, as you say, reversed that decision. Well, a lot of people, on the street, not versed in the law, somehow are persuaded that the lower court judges are somehow against the administration. And as all the judges are doing is trying their best to apply the law. And so it disserves justice, in all honesty, to leave in the minds of people that somehow the Supreme Court is protecting this administration from lower court judges. And that just feeds into this misinformation, this distorted view that so many in high office continue to create, that the judiciary is full of lunatics and activists, and nothing could be further from the truth. So hopefully, in the fullness of time, hopefully not too far in the future, this landscape that's been created through the procedural processes that have been employed will see the light of day. And one of the things that the Article 3 Coalition is trying so desperately to do, to continue to educate people about the role of judges and how reasoned judgment is the coin of the realm when it comes to the judiciary.
And Judge Michel, Justice Neil Gorsuch recently admonished federal judges not to defy the Supreme Court, saying they weren't following precedent from the emergency docket. And Boston federal judge Allison Burroughs reacted to that and said that it was unhelpful and unnecessary to criticize district courts that are working to make sense of Supreme Court orders that are not, quote, models of clarity. And another federal judge, William Young, said he didn't understand that orders on the emergency docket were precedent. He said, I stand corrected. I mean, what do you think the impact is of a Supreme Court justice calling out federal judges?
Well, one complexity that the public doesn't understand, but it's rather important, is that nearly all of the injunctions that have been issued by the district judges around the country in these hundreds of suits challenging Trump administration actions are very preliminary. And that's because there hasn't yet been a trial. There hasn't yet been a final resolution of disputed facts. The district judge is making a prediction, a judgment, that likely the challenger will win over the administration's defense. But it's a speculative judgment. I'm not defensive of the Supreme Court and the extent to which they've intervened. But it is important to recognize that they aren't saying the administration was right and the district judge was wrong. What they're really saying is we don't know for sure yet, so we're going to delay a remedy until there's been actual fact findings and what lawyers call a final judgment. But beyond that, it is certainly true that some of these orders have no reasoning coming down from the Supreme Court. Others are very terse and sometimes unclear. I don't think it's helpful for Judge Burroughs and the Supreme Court justices to get in a public shouting match, but she has a point. The district judges are striving to apply the law faithfully and impartially. And I think usually they get it right, and particularly where they're upheld, as has been true in a number of these cases, by the Court of Appeals above them, the Supreme Court ought to be very hesitant to jump in and overrule both of the so-called lower courts. But in terms of the admonition from Judge Gorsuch, I don't know what he's talking about. I don't see any judge, including Judge William Young in Boston, as being defiant, as refusing to follow some clear direction from the Supreme Court. So I'm not quite sure what he's referring to, but it's not very helpful. And it's a further demoralization of the district judges who do 90% of the work in the judicial system and who should be respected and supported by the public and by the rest of the judicial establishment, and not pilloried as if they're rebellious children or something, because they're not.
Thank you both so much for joining me today. That's Judge Paul Michel and Judge Andre Davis. Coming up next on the Bloomberg Law Show, do lawsuits over tribal sacred sites show unequal protection for religious rights? I'm June Grasso, and you're listening to Bloomberg. For centuries, Western Apaches have worshipped at Oak Flat, a 7-square-mile sacred tribal site in Arizona, where tribal members hold religious ceremonies they say can't take place anywhere else.
That is what keeps us who we are. That is the thing, the spiritual connection to Nagusan, to our Mother Earth, to Yosin, the Creator, to Chichil, to Zitlan Chasian, and to all sacred sites as Indigenous people is what keeps us here today.
For example, there's the sunrise ceremony, a 3-day coming-of-age ceremony for Apache girls that requires gathering certain plants at Oak Flat and being painted with white clay from its ground. For years, Apache Stronghold, a nonprofit coalition of tribal members, has been trying to stop the federal government from transferring the land to a foreign copper mining company whose excavation would destroy the site. The Ninth Circuit has rejected the tribal group's attempts to protect Oak Flat on religious grounds, and the Supreme Court has refused to take the case. A group of Apache women has filed a new suit based on a June decision by the Supreme Court that expanded the religious rights of public school parents. It all brings up the question of whether tribal religious freedom claims are getting equal treatment. A dissent by Justice Neil Gorsuch seems to suggest they're not. My guest is Heather Whiteman Runs Him, director of the Tribal Justice Clinic at the University of Arizona. Heather, can you give us the background of this legal fight?
In 2014, Congress passed the Southern Arizona Land Exchange and Conservation Act as part of a much larger defense authorization bill that, was really so voluminous that it didn't have a whole lot of review, and people weren't paying super close attention to some of the smaller parts of that much larger piece of legislation. And because of that, this particular bill was able to make its way through congressional ratification and was signed into law by President Obama. This particular initiative had been a standalone bill numerous times before and had never moved forward, never been able to get through Congress. What the bill does is it mandates the transfer of Forest Service lands to a private company, Resolution Copper, for the purpose of mining a substantial deposit of copper that underlies the surface of that land. The reason why that's been opposed for so many years is because the land on the surface is the site of very significant, long-standing religious practices by the Western Apache people. And so the mining of the copper will result in the complete destruction of a substantial area of the surface land. It will subside. It will create a very large crater. It won't be usable any longer for the purposes that the Apache people have maintained on that land for hundreds and hundreds of years, if not longer. And so that, according to the Apache people, is a substantial burden on their religious practice. And common sense would, I think, lead anybody to a similar result, that if you destroy the land that is absolutely necessary for the practice of a religion, that's a burden. So that's the conflict in essence.
Apache Stronghold says that Oak Flat is the only place where certain religious ceremonies can take place. Tell us about the sunrise ceremony, which is often mentioned.
Oak Flat is the site where female members of the San Carlos Apache tribe have their coming-of-age ceremonies. So it's where a girl becomes a woman, and there's a specific ceremony that takes place when a girl becomes a woman. It's a very intensive, multi-day ceremony. It's incredibly onerous physically. There's a lot of prayer. A whole community comes together to help bring a girl into womanhood. It's a necessity for a woman to go through that ceremony to fully realize her identity as an Apache woman. So it's incredibly significant. It's one of the most important things that happens in any woman's life in that culture.
So the nonprofit tribal rights group sued to stop the land transfer on religious grounds under the First Amendment and the Religious Freedom Restoration Act. They lost at the Ninth Circuit. Will you explain why the Ninth Circuit found that the land transfer couldn't be considered a substantial burden on religious exercise?
So the Ninth Circuit opinion, it's a tough one to parse out. And so there are a couple of different things that happen there. First, the court ruled that there was no substantial burden because there's not coercion. The Ninth Circuit has a very narrow definition of substantial burden and of coercion. So they have ruled that in the absence of withholding of a benefit because of a religious practice or a punitive or punishment type of provision in a generally applicable federal law that is triggered by what would otherwise be, a basic exercise of a religious practice, that there's no coercion that results in no substantial burden.
Will you tell us more about how Native American religious practices require relationships with specific locations and how that played into the arguments?
And that's the second part of the Ninth Circuit en banc holding. So the first is applying this really narrow standard, really restrictive standard for finding a substantial burden. And second, a different majority of the Ninth Circuit then held that where there's a federal property management initiative, that cannot burden religious freedom rights. Under the Ninth Circuit ruling, we're limited from ever bringing any kind of claim then, saying that a federal land management decision substantially burdens our free exercise rights because it's federal property. The federal government has a right to do what it wants with its own land. And that just doesn't seem right to me, that we can't limit the federal government from violating the First Amendment because the federal government is the landowner. So the analysis under the Ninth Circuit approach is really that the relief sought to limit our ability to ever find an injury to people's First Amendment rights. So we can't find a burden because the relief that we're seeking will limit what the federal government as a landowner can do with its own property. It certainly presents a real challenge to any Native American person whose religious beliefs depend on a relationship with a specific land base, and many of ours do. Many of us have religions and religious practices and beliefs that require specific things to happen in specific places, often at specific times, and that is our sincerely held religious belief and how we practice it. So it renders Native American religious beliefs virtually unprotectable in many instances under the way that the case law has developed. And I just think that can't be right. And I hope most Americans would consider that situation and feel similarly, that simply cannot be correct and that cannot be consistent with our Constitution or what our founders intended.
Apache Stronghold took the case up to the Supreme Court, but the court refused to take the case. However, Justice Neil Gorsuch wrote a powerful dissent joined by Justice Clarence Thomas. He said it was a grave mistake for the court not to take the case. Quote, "Just imagine if the government sought to demolish a historic cathedral on so questionable a chain of legal reasoning. I have no doubt that we would find that case worth our time. Faced with the government's plan to destroy an ancient site of tribal worship, we owe the Apaches no less." And this is a Supreme Court that has expanded religious rights. Do you see a difference with the way tribal religion has been treated?
I see a difference. A lot of people see a difference. Justice Gorsuch's dissent is a really great read. I'd encourage anybody interested in these issues to read it. And I think it recognizes that, like I was saying earlier, the way that these cases are evaluated and the outcomes that we keep seeing should be a concern to every American. Every American citizen should worry about the viability of their free exercise rights. If the court can condone the complete annihilation of a place of worship that is absolutely central to the perpetuation of that religion, they can limit anybody's religious exercise rights. So this is a threat to every American's religious liberty, and it is something that I think we should all be concerned about, that, we need to work through these issues and we need to find solutions that will bring us different results ultimately.
The Supreme Court in June expanded the religious rights of public school parents, ruling that public school parents have the right to opt their children out of classroom lessons that intrude on their religious beliefs. In that case, the Mahmoud case, it was the reading of LGBTQ-friendly books in the classroom that parents objected to. How does that case affect Apache Stronghold's case?
Soon after the denial of cert, Apache Stronghold attorneys filed a petition for basically a reconsideration of the cert petition, asking the Supreme Court to grant certiorari, remand the case back to the Ninth Circuit, and provide clear direction to the Ninth Circuit on how to review the legal arguments going forward in a new Ninth Circuit review. Part of the reason for that is because intervening precedent was decided after the denial of certiorari. The Apache Stronghold's petition for reconsideration relies heavily on the intervening decision in Mahmoud because there are similar impacts of the government policy that's challenged there. In Mahmoud, we had the Supreme Court recognize very, very vehemently that when we limit parents' abilities to bring up their children, to raise their children in ways that are consistent with their religious beliefs, we are violating their First Amendment rights. That is a substantial burden, and it has to go through the relevant analysis for when and how such burdens are limited and when they're allowed to go forward. That type of test has not been applied yet to the challenge law, to the Land Exchange Act in Apache Stronghold. What we've been through so far is the preliminary injunction analysis. So we haven't had the full review of an application of the relevant legal standards for what's permissible, when, and how.
And tell us about the new case that's been filed by Apache women.
The new case that has been filed by a group of Apache women, mothers and daughters, that really found its claims in similar issues and similar analysis to what the Supreme Court decided in Mahmoud. The Land Exchange Act will burden the free exercise rights of especially Apache women because it's limiting Apache women from having the ability to become women in ways that are consistent with their religious beliefs. It's limiting Apache mothers from bringing their daughters into womanhood as required by their religious beliefs. And so there's, a real consistency with the impact on and the burden on a religious freedom interest there as what we saw the Supreme Court limit in Mahmoud.
And the land transfer was stopped for the time being?
The Ninth Circuit Court of Appeals issued an emergency injunction, basically preventing the land transfer. The land transfer was about to take place, put the cases on an expedited briefing schedule, and so we're now in the middle of that briefing to the Ninth Circuit. Oral argument will probably take place early this fall, and we'll see how the Ninth Circuit resolves this issue. So yeah, there's still a lot of activity surrounding various parties' claims in relation to the final disposition of Oak Flat.
We'll certainly follow the oral arguments when they take place. Thanks so much, Heather. That's Heather Whiteman Runs Him, Director of the Tribal Justice Clinic at the University of Arizona.
And that's it for this edition of the Bloomberg Law Show. Remember, you can always get the latest legal news on our Bloomberg Law podcast. You can find them on Apple Podcasts, Spotify, and at www.bloomberg.com/podcast/law. And remember to tune into the Bloomberg Law Show every weeknight at 10 p.m. Wall Street time. I'm June Grasso, and you're listening to Bloomberg.